Welcome to the session, the first set of parallel sessions in the NERI Labour Market Conference for 2025. This session is on collective bargaining. My name is Dr. Tom McDonnell from the Nevin Economic Research Institute. I'm its co-director. Unfortunately, one of our three speakers, Christine Aumayr-Pintar from Eurofound, is ill, so we will only have two speakers, which means people can be a little bit more gentle on themselves in terms of time, which gives you more time to consider and spend time on your slides, which is positive at least. So we will have two speakers. First up, we have Mr. Ger Gibbons from the Irish Congress of Trade Unions. Ger is the social policy and legislative officer, a role he has held since early 2018, and his work focuses on shaping and advocating for progressive social and labour policies at both national and European levels. Ger is going to ask the question, is Ireland in breach of the Adequate Minimum Wages Directive? Ger, the session doesn't end till 12:05, so you can take a little bit more time, but I will sign to you when time's running out.
Grant. Okay,
Good
thanks
luck.
very much, Tom. Um, just to say, I'm not speaking just at the opening remarks. I'm not speaking on behalf of the Irish Congress of Trade Unions here. I'm speaking on my own behalf. There's a number of issues here that we haven't taken a formal position on, so I just want to put in that just that note at the very beginning. So what I want to talk about is just to ask the question, is Ireland in breach of the Adequate Minimum Wages Directive? So what I will do is I will just firstly just go through a number of actions taken by the Irish government over the last 5 years, outline then the Irish government's position on the transposition of this directive, and then look at a number of provisions of the directive where questions could be asked about whether Ireland has done it correctly, particularly in relation to the minimum wage aspects. And then, even though the session is on collective bargaining, I think most of my piece will be on the kind of the minimum wages provisions, but that's kind of to set the context for the collective bargaining provisions. And then just to make a number of conclusions. Lastly, I'm not going to say anything about the ongoing Danish challenge to the directive. I'm working on the assumption that well, the directive is still binding as we speak at the moment. So I'm just leaving that aside. That ruling should be a final ruling over the next number of months. So we're hopeful that the opinion that was delivered in January will be overturned, but you can never judge on these cases. So I'm not going to address that point at all. Firstly, just looking at a number of actions taken by the Irish government over the last 5 years, people might remember back in February 21, the Irish government signed a letter to the then German presidency arguing that a non-binding recommendation would be preferable to a binding directive because, quote, it would give the flexibility for member states to achieve the objectives. Now, this letter was co-signed by Austria, Denmark, Estonia, Hungary, Malta, the Netherlands, Poland, and Sweden. Some of those countries have very good collective bargaining systems, some don't. And I remember at the time, trade union colleagues from across Europe were asking, why is Ireland aligning itself with the likes of Hungary on this matter? So that's just one action. On the other hand, then Ireland did vote for the directive in the Council in October 2022, whereas Denmark and Sweden voted against and Hungary abstained. Now, I suppose if you were being slightly cynical, you could say, well, I think they read the room well and that they realised there was an overwhelming majority in favour of the legislation as it passed. But just to acknowledge that the Irish government did vote in favour of the directive. 12 of the 13 Irish MEPs at the time did the same. The 13th wasn't there, and that's not a hanging matter. So that's the counter argument. I suppose, again, kind of turning to the other side, when Denmark launched its case back in 2023, it too wrote to the government asking the government to intervene in support of the directive. I think the response that it too got back was that we support the directive, but we're not well, they didn't say they weren't going to intervene, but they didn't intervene. But you can see the countries that did intervene in support of the directive: Belgium, Germany, Greece, Spain, France, Luxembourg, and Portugal. None of those countries signed the letter back in 2021. The last point I would just make is that people might be aware that in April 2024, the European institutions with some of the social partners signed the La Hulp Declaration on the future of the European Pillar of Social Rights, and that had referred to further reinforcing collective bargaining. Now, the Irish government was one of two countries that put in statements to that, and I just put in the quote on that. It was the only part that they raised, but they emphasised, or they said that, industrial relations in Ireland is essentially voluntary in nature. There has been agreement on all sides that this is best done by voluntary collective bargaining without the intervention of the state. Now, just to say in relation to agreement on all sides, ICTU wasn't consulted on this at the time. So that's kind of just the backdrop of where the actions that Ireland has taken over the last number of years. The next point I just wanted to discuss is what is the government's position on transposition? And this quote is taken from the ministerial briefing that the Department of Enterprise issued in January of this year in relation to the directive. They essentially said that it was transposed by means of a statutory instrument last November. It met the transposition deadline. It was necessary to amend Ireland's National Minimum Wage Act to give effect to the directive. It said, and this has been repeated on many, many occasions, that the Low Pay Commission was already largely in compliance. There were some minor amendments necessary, and these were made to bring the framework completely into line with the directive. Now, that's the official position. If questions are asked in the Dáil, that's the response. Ireland transposed the directive by means of a statutory instrument last November. So what I want to do then is to just look at a number of areas where, well, can questions be asked about, even in relation to the minimum wage aspect as to what Ireland has done. Just in relation to the first article, or sorry, Article 2 of the directive, and that outlines which workers are covered by the directive. It states that it applies to all workers with an employment contract or relationship in consideration of the criteria of the European Court of Justice. Now, to summarize very, very briefly, they essentially state that if you perform work, if you work under instruction and you receive pay, you're a worker covered by the directive. They don't just specify the criteria because these are the Court of Justice case law, because these are constantly evolving. Back in 2020, when the Commission was issuing the proposal, it identified workers in Ireland who are excluded from the National Minimum Wage Act. Workers who take part in a statutory apprenticeship, close family relatives of an employer, if you're working for your father, for your mother, for your son or your daughter, whatever, and prisoners who take part in work. These are all exempt from the National Minimum Wage Act. So this was identified by the Commission back in 2020. Now, Recital 21 of the directive gives examples of non-standard workers who fulfill the criteria who should be covered by the directive, and it explicitly references apprentices. So the ministerial briefing that the Department of Enterprise issued in January, it says that they are now engaging with the Department of Further and Higher Education and Justice in relation to the exemptions from the National Minimum Wage Act, and they list the three categories of workers who are exempt. But I suppose the question could be asked, if the directive has been fully transposed, why is the department now engaging on these matters? So that's just one area where there's potentially a breach. The next one I just want to talk about is Article 5, the procedure for setting adequate statutory minimum wages, and just in relation to the overarching objectives. Now, the directive talks about, the setting and updating shall be guided by criteria set to contribute to their adequacy with the aim of achieving a decent standard of living, reducing in-work poverty, promoting social cohesion and upward social convergence, and reducing the gender pay gap. Now, the Commission, in the expert group report of 2023, it says, okay, well, we will not assess whether these things have been implemented or transposed in national legislation, but the implementation of the directive should contribute to achieving these overall aims. So it's kind of like these are the backdrop. So I'm just asking the question, well, are these overarching objectives acknowledged either explicitly or implicitly in the directive now? And Alan, I know you've raised this in your chapter on the book about, are the gender pay gap, is that kind of addressed in other areas? I suppose the question can be asked, is this something that needs to be considered further? They're not actually explicit obligations, but it's kind of like they're supposed to be moving in those directions. So that's one area that I think needs further consideration. More specifically then, just going back to the criteria, there are 4 obligatory criteria that have to be considered when member states with statutory minimum wages are setting their minimum wages. The purchasing power of statutory minimum wages, taking the cost of living into account, the general level of wages and their distribution, the growth rate of wages, and long-term national productivity levels and developments. Now, these criteria have to be defined in a clear way, and member states may decide or have the right to kind of attach weights to these criteria. So you can see a quote there from the Commission again in the expert group report. The guiding criteria should be set to contribute to their adequacy. So it's kind of like the emphasis on ensuring the adequacy of minimum wages. Just looking at this now, what I've done is it's a cut and paste for each of these. So the obligatory criteria here in relation to purchasing power. The purchasing power of statutory minimum wage is taking the cost of living into account. This then is what the Irish legislation, as amended by the statutory instrument, provides. Is supposed to consider the likely effect on the cost of living, but then also the purchasing power, taking the cost of living into account. So is there a potential conflict there? Is that clear? Does it contribute to adequacy? That's that one. The next one then is the general level of wages. What's obligatory is on the left-hand side. What's in the Irish legislation, as I see it, to be honest, and it's not, this is my own reading of it, when making a recommendation, the Low Pay Commission shall have regard to changes in earnings during the relevant period, including their growth rate, general levels, and distribution. Now, is considering changes in earnings over a one-year period the same as looking at the general level of wages, the distribution, and the growth rate of wages? So it's just asking these questions about these things. Productivity. You're supposed to consider the long-term productivity, national productivity levels and developments. That's a quote there from an extract there from the European Commission's views. In particular, this formulation, this national, is aimed at avoiding that the directive is interpreted as giving grounds to lower minimum wages for some workers. The Irish legislation then talks about during the relevant period, i.e. effectively 1 year, productivity has been increasing or decreasing, both generally and in the sectors most affected. So I think there's a potential conflict there. It also then has to consider long-term national productivity. So the question I'm asking is this clear? Is the Irish legislation clear on these things? And does it contribute to adequacy? The last one then is, now I suppose, sorry, just in relation to those, I could be reading too much in all of these. That, if there was a discussion on these, you'd say, well, actually, this is how it is done in practice. But I suppose that raises the next article that I'm just jumping ahead. Article 7 talks about the involvement of the social partners in setting statutory minimum wages. And it lists a number of areas where the social partners were to be explicitly involved, including in the selection and the application of criteria for determining the national minimum wage. Now, in the expert group report, the Commission was asked, well, what do you mean by involvement? And they said, well, it could be like giving the social partners the opportunity to present their opinions before any decisions are taken and to get a reasoned response to those opinions. And it also said that, involvement meant more than just engaging with social partners through bodies like the Low Pay Commission. So that was part of it, but it also had to be much more. But just to say that, as far as we're aware, the trade unions were not involved, not consulted by the government before that statutory instrument was adopted last November. So I think, again, that's something that, there was no opportunity to thrash out these issues as the government, as the department was considering these. Moving back a bit then, Article 6, it talks about, regulating variations, i.e. reduced rates for younger workers or deductions, that any such variations or deductions must respect the principles of non-discrimination and proportionality, including the pursuit of a legitimate aim. In the expert group report, the Commission said that it is the responsibilities of member states to review any variations they have and to eliminate those that are discriminatory or not proportionate by the transposition deadline, which was the 15th of November last year. Last March 24, the Low Pay Commission, in its report on these variations, said it couldn't identify any objective justification for the reduced rates for younger workers, and it recommended their abolition from January 2025. In July, a few months later, the department announced that it was commissioning an economic assessment of the Low Pay Commission's report, and that report is expected over the coming months. But then in April, it basically said that decisions on the youth rates will be deferred. So if the Commission is saying they had to be abolished, if you couldn't find an objective justification, they had to be abolished by November, and the government is saying, well, we'll defer the um, decision. Moving on then, Article 12 talks about protecting workers and workers' representatives, including those who are trade union members or representatives, from any adverse treatment by an employer or adverse consequences as a result of taking a complaint. This applies to the national minimum wage, and according to the Commission in the expert group report, it would also apply to employment regulation orders. In theory, then it should also apply to sectoral employment orders. Again, I'm quoting the work that Alan has done. The National Minimum Wage Act prohibits discrimination of employees, but it doesn't explicitly protect workers' representatives, and in theory, it doesn't explicitly protect trade union members or representatives. Again, kind of linked to that then, penalties for any breaches of rights under the directive are supposed to be effective, proportionate, and dissuasive. Again, if it doesn't protect workers' representatives of trade union members, what penalties are there for protecting trade union members and workers' representatives whose rights have been breached under this legislation? So again, there are questions that, I suppose, if the government is saying that it has transposed the directive correctly, these are all things that I think warrant some further consideration. So I suppose it's to set the framework then for the final couple of slides I think I have, yes. I suppose the minimum wages, it's the adequate minimum wages directive, but really the most substantial parts to it are the provisions on collective bargaining. Article 4, I'm not going to go into them here, but they do require member states, all member states, to take specific actions to increase collective bargaining coverage and facilitate the exercise of the right to collective bargaining. Now, a range of bodies and academics in Ireland, some of whom are here, have kind of identified the weaknesses or the non-existence of the right to collective bargaining in Ireland. NESC, the SRI, the Irish Human Rights and Equality Commission. So just putting the third point there is again a quote from the department's ministerial brief of last January. There were no legislative changes on the collective bargaining side because the relevant provisions are already being given effect. And the formulation of the action plan does not need a legislative underpinning. Now, as far as we're aware, nobody has ever said that the action plan requires legislation because the action plan to promote collective bargaining is part of the implementation. It's what you do once you have all the legislation in place. But if the collective bargaining provisions are already being given effect, we would love to know where they are in the Irish context because we don't know where they are. And again, I suppose just going back to the whole declaration, the obligation to promote collective bargaining, can that be reconciled with the government's view that, you know, there is widespread agreement that terms and conditions of employment are best determined by voluntary collective bargaining without the intervention of the state? The purpose of the directive, of these provisions of the directive, are to promote collective bargaining. That requires the intervention of the state. The last slide then I have is just to say that, look, I suppose it's really to ask questions about, look, the government says that it has transposed the directive by means of the statutory instrument last year. I think questions can be asked about some of those provisions. And I think there is recognition across Europe that, look, this is completely different to any piece of social legislation that has been adopted before. It is a paradigm change. And I just want to quote something that Michael Doherty wrote last year. The obligations on the directive are clear. Member states shall promote collective bargaining. So it's kind of, I think there is a need for policymakers and the government to realise the importance of this piece of legislation. I've put in a quote there from Eoin Reedy, our General Secretary, when he spoke before the Oireachtas Committee January of last year, that we see it, the trade union movement sees this as the most important and significant piece of legislation to come from Europe in a generation. And I suppose if the government needs to be aware of how the trade union movement sees this piece of legislation, that if it is a kind of if there is an effective reneging on the obligations that Ireland has undertaken, that will undoubtedly affect how the trade movement engages in the wider debate on the future of Europe. So I'll leave it at that. I think that's just the last one there. There's a couple of quotes that I've taken, so that's it. So if any questions, I'll be doing my best.
So thank you, thank you very much for that, Ger. Very, very interesting. So I'd like to take the opportunity to open the floor to questions or comments. Time is not necessarily a factor here, so we're good to go. Kevin, you go first.
Thanks, Tom. Jared, thank you for that. I just want to make a comment on the right to collective bargaining. Under international law, going back to 1949, I think, the ILO Convention on the right to collective bargaining has been there. Ireland signed that. That resolution was updated, I think, in the 1960s. And I checked with the Department of Enterprise, and as far as I can find from the ILO website, Ireland didn't sign the updated resolution. Anyway, that's one side. Under the fundamental rights, this is part of the EU treaties, there are two articles in the fundamental rights that are legal, that collective bargaining is written into the fundamental rights, which is also part, and we have signed the treaty. So it's a legal situation here. And also under the Council of Europe. The Council of Europe have, which Ireland has signed, under the social policy of the Council of Europe, we have signed up to the right to collective bargaining. So, whether under national law we're entitled to collective bargaining, certainly under international law it's written into our legislation.
You want to reflect upon that, Chair?
No, just to acknowledge that I think all of those international instruments are explicitly cited and more in the recitals to the directive. And when the Commission, again in the expert group report, the European Commission said that, look, all of the provisions of Article 4 were inspired by the ILO conventions that all member states have signed. And then it referenced a number of other ones. We just, the government or the Department of Enterprise recently held a public consultation on what should be in the action plan. And in the submission that ICTU did, and I know other trade union and affiliated trade unions did as well, there is explicit references going back to all of the ILO conventions and other instruments that Ireland has signed and ratified over the last number of years. So, this is really what this is about, is giving effect to instruments that Ireland ratified 60, 70 years ago. Or seeking to.
Yes, of course.
In relation to protection for union membership and union representatives, sorry, John Carty. In relation to protections for union members and union activists, there is on the statute books the Unfair Dismissals Act that prohibits the dismissal of a union member or for union members for activity. But all it does is protect in relation to dismissal. Demotion, cutting of hours, transfers, there's nothing there on that. And although the Act was amended in 1993, the maximum penalty on an employer as far as punitive damages is 4 weeks. That's not sufficient to deter an anti-union employer victimising union activity. And the fact that in your own slide you mentioned the non-intervention of the state. To quote Professor Richard Hyman, the state is never neutral in industrial relations. It's always neutral on the side of capital. Thank you.
Well, no, again, I mean, I didn't go into it there, but it's kind of the provisions that are under Article 4. It talks about protecting workers in respect of their employment, and it requires member states to take action as appropriate. And again, the Commission was asked, well, what does the as appropriate mean? And it said, well, it was an acknowledgement that some member states do have good protections in place for trade union members, but it follows that if a member state doesn't have good protection, it is obliged to put them in place. So I think it kind of like it wasn't saying that every country needs to do something on this, that it was an acknowledgement that some countries do have relatively good protections in place for workers. And the other side of that then is, and it's a part that isn't really, the government hasn't really, or the department hasn't really engaged on, it's not just about protecting workers who want to join a trade union. It's also about protecting unions from acts of interference by employers. So there's two sides to it. So, and I think that's something that the government hasn't really so far hasn't really acknowledged. And again, there's provision there that as appropriate, to take measures as appropriate. So it leaves it up to member states. The government is supposed to review the legislation that it has in place. But it goes back to what I was saying there, that, all of the measures are already being given effect. So there's a sort of a contradiction there. If they're being given effect, indicated, they haven't done that. So I think we're in the middle of this process. I think that's really what this is all about.
Alan?
Alan Eustace, Trinity College, Dublin. Ger, thank you very much for engaging with some of the work that I've done with Mark Bell on this. I suppose just a couple of points, maybe the lawyer's perspective. I'm trying to imagine what a legal challenge looks like that addresses the points that you've raised. One possibility would be that the Low Pay Commission issues a recommendation and the minister promulgates an SI updating the minimum wage. A judicial review of that, arguing that the factors in the Minimum Wage Act do not properly reflect the requirements of the directive. That's one possible way that this issue would end up being addressed. On the question of variations and deductions, I think that's actually much easier to see a legal challenge on that basis. I mean, it would look like somebody who's being paid, a young worker being paid less than the minimum wage that applies to older workers, challenging that as being breach of the Minimum Wage Act, losing in the WRC, and then seeking, a case stated to the High Court or something like that. And again, then it would come down to, does the directive adequately, or does the Minimum Wage Act adequately transpose the directive? On the question of the of penalisation, I'm leaning towards the view that probably the fact that the Minimum Wage Act doesn't refer specifically to trade unions is a problem, but that a lot of cases in practice might be captured by other legislation that protects trade union activity more generally. But I think there are weaknesses there. So, there was a big case in the UK over the last couple of years, the Mercer decision, where effectively the UK court reviewed. Yeah, I will finish up now. Sorry, reviewed the whether the UK law, which is similar enough to Irish legislation, is compliant with the European Convention on Human Rights. I've taken the view before that Irish legislation is similarly flawed. And so again, I could see potential legal action that would hit that point as well.
Thank you very much. We've a number of three more potential contributors, so I might take those three together. But before that, do you want to respond to
Yeah, no, absolutely. I mean, this is the kind of conversation that should have been taking place this time last year with the department, to be honest. Because these are the things, there are issues there, and it's very, very useful to hear what's been said. The last thing I just want to put up there, I didn't refer to it, but again, from the expert group report, social partners have a role to play in monitoring compliance with the directive and should inform the Commission in case of any perceived non-compliance. That's also the option. I think there's other things, I've seen that I think a citizen in Greece has tabled a petition to the European Parliament's Petitions Committee about Greece's non-compliance with the directive. That has been accepted as valid. There's various things that can be done. I mean, none of them is a magic bullet to solve all of these things, but I think there are things that can be done. And, the trade union movement will look at all of these and decide what steps are taken. With the Irish presidency coming up next year, big fanfare for the Irish government, and we'll see what happens. Yeah.
Chance to embarrass. Okay, so three more questions. I'll do them in the order I saw them. Suzanne.
Thanks very much, Suzanne, Social Justice Ireland. And I suppose I deliberately went into rooms that I know the least about. So if you go back one or two slides, I just have hopefully I probably jinxed it now, a very simple question. When you're talking about the productivity piece, in relation to, where was that now?
Sorry.
In relation to setting it. Yes, there we go. Yeah. So when making a recommendation, the relevant period productivity has been increasing. How is that decided upon? There you go.
To be honest, I think if Michael Taft were here, he would give that afternoon and Brogan were here. They would say how that is done in practice. From what I've heard from them, it is essentially comes down to a process of negotiation at the end of the day between the members of the Low Pay Commission. But I suppose it's really just to say that where you're talking about looking at, the European emphasis is on kind of long-term national productivity so as to avoid individual workers being adversely affected. The Irish piece talks about looking at it during the relevant period, both generally and in sectors most affected. Now, how much weight is given to the sectors most affected? If the accommodation sector is saying, oh, we can't afford this, whatever, it's going to ruin us again, what weight is given to that in the actual negotiation? So it's just to flag the potential. Look, are there things here that are not clear? There's an obligation in the directive on being clear. That the criteria should be determined in a clear way. Is that clear?
Just
Tom?
sorry, just to supplement on the productivity point. Productivity is often very volatile from year to year. It'll shift up and down depending on the composition of employment, such as job creation in low value added sectors. Productivity in the economy might actually fall year on year. In the Republic of Ireland in particular, there are extreme problems associated with the multinationals, which in theory generate very high levels of productivity, and there can be huge surges in productivity year on year based upon the location of IP assets. So that means that relying on the headline CSO figures is very, very challenging. So one of the alternate methods to go by is to say, well, what is the standard productivity gains that you would experience in an advanced economy over the last 20, 30, 40 years? And if you're looking forward at something like a minimum wage, to assume that maybe productivity might grow by 1.5% year on year, but to actually look at the headline productivity figures for a country like the Republic of Ireland is hugely problematic. You would end up with decreases in some years. You could end up with increases of over 10, 15% in other years. It simply wouldn't be acceptable. Even productivity within sectors can be challenging to look at. So it's about that. How do we aim for a standard generic level of productivity, assuming that going forward? Yeah, and you can also rely on things like the Department of Finance estimates, central bank estimates, and things like that as well, if you're the Low Pay Commission. But that would be the best you could probably hope for. Go for it.
Thanks very much, Chair. Michael Doherty. So just like you, people may know I'm the chair of the Employment Law Review Group, yes. But I am here in a personal capacity. I have nothing to say, kind of. So just to follow up, so very quickly, a quick reflection, and unusually for an academic, an actual question. To follow up on John and Alan, like this point about protecting workers' representatives, John has rightly said, when the government has to respond to that, it always says two things. It says, well, there's Unfair Dismissals Act, and John has already pointed out there's problems with the Act, and it doesn't cover anything short of dismissal. And secondly, they always say, and there's a code of practice, which of course is John's reaction there. I don't need to go any further, right? So it's not just the directives, it's the predictable and transparent regulations. There's a number of pieces of relatively recent EU law where, in my view, Ireland is not compliant because it is not protecting workers' representatives. And this could become even more problematic in the context of, say, corporate sustainability due diligence and pay transparency, where employee representatives have to be there even if there is no trade union. So employers have got to find a way of coming up with independent employee representatives, and they have to be protected as well. It's not just not only a trade union issue. So that's the kind of reflection. The question is basically, like when I'm talking about Ireland abroad, I often say, well, the legal framework isn't great, like some other country, like Italy, for example, but the system works better than in a lot of countries, like Italy, for example, because things get done almost in spite of the legal framework. So my question is, would you be optimistic that notwithstanding the gaps that you've identified in transposition, that a robust plan, the action plan actually could solve a lot of these issues?
Very quick response to Michael.
I suppose it depends on what's in the action plan. I mean, I think most of the government's commentary on this so far has been, yes, we will. The only thing we need to do is to do an action plan. and all of the pieces that are kind of on the left-hand side about promoting collective bargaining, there hasn't really been much consideration of those. So what we have said, what we actually said in our submission for the action plan is, okay, it has to be done. It has to be at least every 5 years. We have said it should be a 3-year one, maybe a 4-year one, so that there's a possibility to review, because the directive will be evaluated in 2029. We want to be able to see, well, has it done what it said it would do? And I think it goes back to some of the work that you've done yourself in relation to other articles about the reports. Like, there's so much emphasis, a lot of emphasis on the action plan, but there's also the reporting that the government has to do, by October, and then again in 2027. So there's a few different things there. But look, I suppose the short answer is we'd have to see what's in the action plan. I wouldn't say we're wildly optimistic at this stage about what will be in it, but this is a long-term process.
Okay. And then finally, Eamon.
Oh, yeah. Is this working? Yeah. Oh, yeah. Eamon Sullivan. I'm from Maynooth University. I'm also a taxi driver. I'm doing a PhD, but I'm a taxi driver, and I'm interested in research is looking at the gig economy. And when you talked about the requisites for like what is a minimum wage worker, and it was that they do work, that there's subordination, and that they get paid. And I'm just wondering, then, how is it then that, say, for example, Deliveroo riders, why aren't they considered in the national minimum wage? Because they do work, they are subordinate at least to an algorithm, and they are getting paid. I know there's this talk that the algorithm is doing the subordinating, but in actual fact, the algorithm is just a line of code that's been put in by the employer.
I think just on that slide there, I just refer to recital 21 because it explicitly referenced apprentices, but it also references other non-standard workers who should be covered by the directive if they fulfill the criteria. And from what I can remember, it does explicitly refer to platform workers. So just to go back onto that, if you want to go look back on that, it's basically saying essentially the obligation on the state is to show that they're not covered. So, I think if you go back and look on that recital, I think I didn't do anything on that for this piece because they weren't identified in the Commission's document back in 2020 of workers who were explicitly excluded from the Minimum Wage Act, but they are explicitly referenced in recital 21 of the directive as examples of workers who should be covered by the legislation.
Okay, thank you, Ger. I'm going to leave it at that there, so we have enough time for the final contributors. So with that, so that means I now have begging or bargaining, the changing landscape of collective bargaining, which promises to be very interesting, and of Mr. Eoin Coates from Maynooth University and trade union official, and Dr. John Carty, University of Galway, and trade union official. Thank you, guys. I'll give you the traditional 5-minute warning.
Thank you. Hello, everybody. So by way of introduction, briefly, I suppose, my name is Eoin Coates. I'm a PhD student at Maynooth University and also a full-time trade union official with Mandate Trade Union. I'm joined myself and my colleague in Mandate, John Carty, put this presentation and paper together just to give our perspective. Dr. John Carty will introduce himself, I'm sure. His 33 years experience and my much less than 33 years experience can hopefully come together and present some valid alternatives and some valid suggestions in this constantly evolving debate around collective bargaining in Ireland, which is very positive to see. So just to start off, I think we're looking to take a little bit of a step back from the debate so far. We're hoping to bring a kind of cold-faced view of this. So every single day, even this morning, we're dealing with members. We do mostly retail work, but members that are dealing with the impact of European legislation, which eventually becomes Irish and eventually impacts their lives. So we're trying to see it from that kind of bottom-up perspective, slightly differently, and see what is it that they need, they want, and how can we use this directive to benefit that while also ticking all the boxes, right, including that magical 80% number that somehow we're supposed to aim towards. So firstly, yeah, just to put it in context, some of this stuff has already been mentioned. There is an ECJ pending ruling on the Denmark case. I put that in because knowing the way it is, I was expecting to see this morning the news that they'd come out with a ruling on this, and the whole thing would be wasted. So I just put it in just to cover ourselves. But and obviously this is solely within the context of the minimum wage directive. We also want to look at some realistic alternatives here, and I put the current political climate in there because, as Ger has much more eloquently discussed, we do have a political reality in this country that will exist throughout the transposition timeline of this directive, um, you would imagine. And we want to look at, realistic approaches. And for that, we're looking abroad. We're looking at the rest of Europe and pulling specific cases from there. As I mentioned, I've already introduced this, but there is the two parts to it. So firstly, I'll do a bit of an introduction and I'll hand over to John, who will look more so from where we're starting on this. So we're looking at, the fundamentals as we see it. So that unions only can have a say at the table due to leverage, due to that power and that power balance between workers and employers. That, in our view, needs to be maintained. In addition to that, and I'll focus more so on this, is workplace democracy. So we're strong believers in that. I think the membership of trade unions are, and that is something that I think has always been a challenge, particularly if we look at it realistically, if we're looking at that 80% number and saying, if sectoral bargaining is to grow, there's particular challenges in that. But even from a purely organizing perspective, we have to face reality that the coverage, the density of trade unions in employers is quite small, particularly compared to our European peers. I briefly touched on this already, but just to kind of emphasize the point, crucially on leverage, the whole industrial relations system, as you all know well, is built on this power balance between the two, between the workers and employers. That over generations, particularly in the UK and also in Ireland, we've seen slowly that the structures put in place that there is state intervention, but not the kind of state intervention that the trade unions are looking for. There is all options there that, this is not to take a dig at things like the WRC, but at the same time, there is ways of resolving your issues outside the kind of traditional industrial muscle, for want of a better phrase. But fundamental to all that, and of course to unions itself, is that democracy. So it's important that no matter what we do throughout this, and it's also important to say, regardless of what happens with this directive in Ireland, this conversation needs to continue about collective bargaining. But regardless of that, particularly how we can improve the engagement of workers, because that is a real challenge we have on the shop floor, on the coal face, that we can't get engagement from people on these issues in particular. And lastly, we looked as well at opportunities. So my piece, which I'll come in with later, we look around Europe and we focus more so on the PIGS countries, as we became known during the difficult years, as they would say, and I'll explain that a bit later. But there is opportunities there, I think, that present opportunities for greater access, which is a major demand of the trade union movement in this area, but also greater engagement with the workers. So we'll come around to all that a bit later. But for now, I'll hand it over to John. John's going to walk you through some of the more fundamental pieces.
John Carty, I'm working with Mandate since 1999. I'm here in a personal capacity, no more than my colleague Eoin. And before that, I was the elected full-time union convener for the Amalgamated Engineering Union, which is now Party Unite. The ILO was mentioned earlier, and it does consider the right to strike as an essential principle. The problem with the ILO is it's not a court of law. It can't enforce countries to abide by the principles they've signed up to. Back in 1980, the German Federal Court issued a decision: collective bargaining without the possible resort to instrument of strike would be no more than collective begging. Think about that for a minute. You have a group of union representatives in a room. If they don't have some sort of leverage over the employer that's in the room, they're just being consulted. It's not bargaining. The South African court, workers therefore need to act in concert to provide them collectively with sufficient power to bargain effectively with employers. Workers exercise collective power primarily through mechanism of strike action. And the Canadian court stated without the right to strike, the right to organise and bargain collectively are virtually meaningless. And the court went on to state that without the right to strike, a union is a barren and useless thing. Whether it's the Low Pay Commission or JLC's, Joint Labour Committees, or any other engagement between the social partners, unless the workers' representatives have an obligation to ballot their members on any outcome, and the members have a democratic right, if necessary, to vote against the proposal, and have a democratic right in a free society to withdraw their labour, it's not collective bargaining. Another academic, John Hindy, a leading international expert on employment law, concludes that, or concurs and states, the right to strike is an essential element in the right to bargain collectively. He went on to say with Professor Keith Eoin that the term collective bargaining expanded on the term collective bargaining and stated without rights, trade unions are no more than pressure groups. And went on to state, without an effective right to strike, collective bargaining is not possible. In the absence of a right to strike, collective bargaining is no more than collective begging. No employer will make concessions if the union cannot realistically threaten to withdraw labour. And my final slide for the moment, Bob Heap, in his address to the Countess Markovich lecture on UCD, co-authored a work, cited co-authored work, which was also quoted by the Canadian Supreme Court, and went on to state the power to withdraw their labour is for workers what management is the power to shut down production, to switch it to different purposes, to transfer to different places, etc. Now, in retail, the employers aren't able to threaten. Tesco can threaten to close their store in Galway and move it to Warsaw, because the Galway shoppers will not go to Warsaw to buy their weekly groceries. But a manufacturing plant can threaten to move to Brazil, China, Scotland, Wales, unless the workers accept what the employer is looking for in relation to wages and terms and conditions. So to have some form of balance, you have to have leverage on the other side of the table, or else it's not bargaining. Ken Gill, former General Secretary of MSF, now Unite, summarised the difference between a slave and a worker is the right to withdraw his, and shown the age, I'd insert or her, labour, quoted in Wilkinson. Slaves may never bargain, but they can always beg. If you're a worker, you need to have the right to withdraw your labour. Thank you.
John, so just building off that, so we decided to have a look at the EU, obviously directive in particular, and how that feeds in, the leverage piece feeds in. And that's a decent background, I think, to understand what we're trying to achieve here and what we're trying to say. So just a bit of my own past, I used to work in Brussels in the European Transport Workers Federation, and was there at the time of the negotiations of this directive. And I think one thing that's sometimes lost in Ireland is the nature of the European Union, particularly when it comes to labour. Nowadays, we are, without the UK, quite isolated in our system, right? Obviously, we have Central and Eastern Europe is kind of similarly voluntaristic, but Ger very usefully pointed out that there was those letters, and you can see a clear division between the member states as to which member state feels what is of what opinion when it comes to labour legislation. This, rather controversially, as we all know, piece of this directive was really, in my view, designed for that kind of Mediterranean, as I refer to it, a continental style, and based off that those principles. So high levels of collective collective bargaining coverage, not necessarily high levels of density, but certainly of coverage. As Denmark has said, it's not for them. And similarly, our government said, well, typical Irish response, sure, it'll be grand. And that's pretty much it. So it is, I think it's important for us always to look at this in that context. What was it built for? What was it designed to do? I think it's very useful to us. It's very good to us, particularly in the Republic of Ireland, But nonetheless, it is important to understand that context of, the big voices in these rooms were from countries like Spain, Italy, France, Germany, etc. And obviously Ireland, as has been pointed out already, is a bit of an outlier in that. So we're, as I say, a little bit out on a limb in terms of both our system and the kind of political objectives that I referred to earlier. One other thing to keep in mind as well, and this is, I suppose, to some extent to defend ourselves. Trade unions in Europe are also a very different background, right? So, trade unions have been around forever, as far as we can remember, since the Industrial Revolution in Ireland in some form. But the history and the kind of cultural context of trade unions on continental Europe is much deeper, and that has allowed for much deeper or much greater power when it comes to the creation of legislation, but particularly nationally, but also to some extent when influencing the European Union. So, it does vary significantly, but countries like, Spain, Italy, Greece, historically, the unions had significant roles in creating the countries that are there today. On the other side of the coin, if you look at countries like Poland, Lithuania, trade unions were historically seen as an extension of the state. So there's definitely, and I have an organized in Poland in particular, there's definitely a kind of a feeling of mistrust towards trade unions in that part of Europe. And again, it's just to point out the kind of differences in Europe here. So you have that mistrust in the East, kind of Central Southern Europe. It's fundamentally part of the country, right, to be a trade union. And then you have the ourselves, the more kind of neoliberalist model, based around voluntarism and individualism. But most importantly, what I wanted to kind of focus on in this piece of work is the Troika era and those PIGS countries as referred to earlier. I think we somewhat lovingly to ourselves constantly say, oh, we're quite like Denmark, we're quite like the Netherlands. And yeah, GDP and population we are, but in this world, in the labor world, we're not. And that's the reality of it. So what I thought might be useful is kind of looking at the country-specific recommendations that kind of arose around 2008. And they apply to all these countries. And looking at them and saying, right, what worked, what didn't work, right? And it varied dramatically. I'm going to pull out these two, but I'll briefly talk about Greece as well. So Greece historically was quite similar, as I mentioned, to Italy and Spain in terms of trade unionism and coverage. But if you look at any statistics, the OECD has very good statistics on this. The coverage and density absolutely plummeted when the Greek government changed the laws off the basis of a country-specific recommendation. But let's not go the way of Greece. We're past that now. I also think it's also useful that the same organization, the European Commission, has put forward both of these, this and 2008 country-specific recommendations, but that's for a different presentation. But what I pulled out is going back to what we were just discussing, what John was just mentioning, this idea of workplace democracy. So good practices, right? Let's focus on the positive here. Good practices. Well, I've pulled specifically Italy and Spain. So if you look at the Italian, now the Italian system generally is not, I have direct democracy. Most of the time, there is no direct vote on a proposal. It is dealt with by the unions, but the mechanism is there to do that. What we're trying to look at here particularly is a sectoral collective bargaining agreement. So in the situation where you have a sectoral collective bargaining agreement, unlike Ireland at the moment, which doesn't provide for kind of a deep level of engagement with workers, we're looking at these options. So Italy has, again, as I mentioned, it's not always the case, but there is provisions in Italian law to allow for that direct vote on a proposal. Secondly, Spain, and this is a similar situation in Germany, quite similar to what we have in Europe in the European Works Council. There is a process in Spain to create works councils. So again, it's not direct. What happens in Spain is you go elect your works council member, they vote on your behalf. So it's indirect democracy. They negotiate on your behalf. But what's crucial about all of this is not the ability for unions to negotiate. It's not about who's better at negotiation, trade union officials, workers, or legislators. It's more to improve that workplace democracy, which in turn feeds into things like leverage, but also feeds into achieving that 80% number and achieving greater engagement from workers on the issue of collective bargaining. Because the reality is, and I remember speaking to some senior political figure at the time. And I said, look, we need to start doing more on this, it needs to become a political priority. And the quote, I won't name names, but to quote them, I said, well, collective bargaining is just not sexy enough. No one knows what it is. And that's the reality, right? If me or John walked into a Tesco or to a Dunnes Stores today and said, you know what collective bargaining is? We get blank stares, blank stares. So the aim of all this is to look at other opportunities, other ways in which we can democratize the whole process. So what can we apply to Ireland? Firstly, as I mentioned briefly, Spain and Italy have very good ways, alternative ways of applying a somewhat democratic process of sectoral collective bargaining. Additionally, in those jurisdictions, there is also provision for local agreement. So I think some of the concern is that if you apply one level of wage or conditions across an entire sector, it just, basically becomes one blob, ruins competition and everything else. In these countries, and I was speaking to Italian trade unions yesterday about this, there is specifically local agreements made. They may be geographic. So you may have a city premium, like the London living wage type of situation. You may have specific like factories that are more productive may get something out of it. There is also local provisions. So the sectoral thing is really just a base. And then it allows unions to provide a union premium on top of that through negotiation, through collective bargaining. Again, strengthening the whole thing. Now, I will say, and I've already mentioned about the history of unions and this much stronger legislative basis that all these in most European countries. And I can't ignore that, because the reality is that these unions have been put in a position of power to achieve these things due to a more friendly legislative environment. I'm sure they'll tell me it's not, thank you, that friendly. But nonetheless, there is things to learn. And the big question for me is, should we look at a continental style of trade unions, continental style of collective bargaining? Is that what the directive is asking us to do? I think to some extent it is. But most importantly, we need to look at what can be used at all countries in the EU, not just in Scandinavia. The very last slide I'll give to John. I've just given the 5-minute warning, John, so you have about 3.5 minutes.
Thank you. So basically what we're trying to do is pull the two parts of the presentation together, right? For collective bargaining to be effective, particularly from a worker's point of view, they need leverage, right? International legal opinion, we've shown, backs that up. Without the right to strike, a union is a barren thing. And without leverage, the right to strike, union negotiators aren't engaged in collective bargaining, but collective flagging, as according to the Germans. Second part of the presentation was we need more democracy in the workplace. In the plenary session earlier on, Michael Taff mentioned about an engaged workforce is more productive. Donald Sassoon wrote a book one time on 100 years of, I think it's European socialism. He says, in a free society, in a democracy, you can vote for any candidate you want. In a consumer society, you can vote for whatever product or service you can afford. But at work, you'll do what you're told. And what we're trying to do is put some democracy into the workplace where the employer is no longer king or queen. This can be achieved through direct or indirect democracy, and democratizing the collective bargaining process presents opportunities to engage the workers, back to the plenary session, engage the workers at a deeper level. Thank you for listening.
Thank you. Thank you to Eoin and to John. We still have about 10 minutes left before the session ends. So that gives us enough time for questions and reflections from the floor. Would anyone like to go first? Kevin, this is you again.
What struck me during the presentation, which I found fascinating, is I was going through my mind, and maybe some of the legal minds here might clarify it for me. The 1941 Trade Union Act, which was found to be unconstitutional. Tom, as you will know, I've had a sort of a checkered career, and part of it was as an advisor in the Department of Labour. And I remember discussing it with the Secretary General of the department as to how we could overcome the unconstitutional aspects of the 1941 Act, which gave trade union recognition. And he told me that he had discussed that with Tiger Carroll, with, well, I have a terrible head for names, with the, he was our president at one stage, he resigned. Anyway, and even in the 1990s, the view was that it would be fairly well impossible to change the unconstitutionality of the 1941. And I think that 1941 Act, and I think that has been a major, major problem in industrial relations in Ireland. And I mean, I've raised this quite a number of times in different fora.
Owen, John, would you like to comment on that?
My opinion is the 1941 Act, right? It wasn't the cause of the problem. The problem was already there, right? It's the Constitution and the way the courts have interpreted the Constitution. The right to association has been interpreted as the right to disassociate, and an employer can disassociate from any particular employer. Yeah, but that, yeah.
Was to try to reform the trade union coming out of the British structures. That's what Sean Lass had in mind. Unfortunately, the Supreme Court in 1949, was it?
It was the Minskill versus CIE case.
Yeah, that's right. But I don't know how to overcome that, because I think that's a big drawback for the Irish trade union.
Well, under the Good Friday Agreement, part of this, the Republic's obligation was to sign up to the European Convention on Human Rights. And that goes stronger than the right to association under the Irish Constitution, but I don't see that coming into effect anytime soon. The right to collective bargaining in trying the law, yeah.
Alan.
Oh, sorry, okay. Sure, no problem. So myself and Michael were just whispering to each other there about who was going to take this bullet. So yes, I think the overall description of hostility in the courts towards an interpretation of Irish constitutional law, which would allow the state to support trade unions more actively, is accurate, but it is worth noting a couple of recent cases in which the Supreme Court has swung, I think, quite dramatically in the opposite direction. So there was on the sort of sectoral side, there was the NECI decision from a couple of years ago, which seems to give the government a lot more power to intervene to support sectoral bargaining. And then at enterprise level, there's the O'Neill and Unite case from last year, which again indicates the court is happy to basically take a hands-off approach, leave it up to the politicians. If the political branches of government want to support trade unions at a sectoral or an enterprise level, as far as the Supreme Court is concerned, they're very unlikely to stop them. At the way the jurisprudence has evolved over time. Michael, I don't know whether you want to weigh in on that as well.
Just to add to your quotes, John, the line that everybody's quoting from the Unite cases, Justice Hogan, he says, trade unions must have a, quote, as yet undefined zone of freedom in which to operate. And I think what the point Alan's making is it's a political question as to how you define that zone. And I think that's partly why the presentation is so important, is because that's what needs to happen now, a real political push, I think.
Yeah, exactly. I think it's bang on. And I think, I do mention the politics, but the one advantage, not the only advantage, one of the key advantages we have in this situation, this point in time, is we have a commission, unlike in 2008, a commission which is very supportive and, pushing for trade unions to have more collective bargaining coverage. It's a directive to say this now. That may all be dead thanks to the ECJ in a few weeks' time, but who knows? But look, nonetheless, I think it's exactly the thing. And but you know, influencing government is the key thing, and this is something that I suppose we see on the front line as well. And the only way we see as trade union practitioners, I suppose, is through those two kind of tenets, leverage and democracy, right? So leverage is key. It's more than just a right to strike. It's you know it's using your we recently had pickets outside Tesco's. There was no right to strike, but picketing, political pressure during elections, all those type of things. And also the reality, as I remind every single politician that I meet, that well, workers are voters too, and I think that's key. And to some extent, I also do think we are slightly not at fault is a bit of a stretch, but we could do more to make it clear to people, not necessarily to employers and to government, they know where we stand, but to workers, to day, just people in Ireland, voters, what we're trying to do. And going back to what I said earlier, no one really knows what collective bargaining is. And then they see a directive called the Minimum Wage Directive and say, oh, sure, our minimum wage isn't this, it's grand compared to the rest of them. Do you know what I mean? So it's about changing the narrative to some extent to try and influence the government, which in turn, ideally, right, will then influence legislation.
John, do you want to add to that?
Yeah, just going back to the comment there about politics, you can't operate an industrial relations system in the absence of politics. And I was at a lecture in anyway Galway, it's called the University of Galway this week. And they were talking about this directive before it ever is seen the light of day, this going back a number of years. And I said one of the reasons for the directive to support collective bargaining and put some life back into the trade union movement in Western Europe or European Union was working class communities that felt alienated were being exploited by the far right. And the way to get around that is have democracy in the workplace. Trade unions don't only operate in the workplace, they have trades councils, right, to put forward people in political parties, all of that. There's more engagement in society when you have, and there's been studies done internationally this, when you have a stronger trade union movement, you have a more stable political system. And that's one of the reasons this directive needs to be properly implemented. Thank you.
We have a tiny bit of time for any final comments or reflections from the floor. Suzanne, go.
Thank you. I'm curious about union and academic third level jobs, because anybody I know who's in, and this might be to the entire group here, but there seems to be an erosion of the rights and pay deals and the types of job contracts that third level academic staff are experiencing. So I'm just wondering, for people in general who are active in unions and work at third level, is there a bit of is that a difficult space to be in, because you're one thing and then obviously your rights are being eroded slowly but surely over time?
Just briefly, and I don't represent a university trade union, but I will introduce you to a fellow that's at this conference, Paddy McDonnell. He works for the university union up here in the north. And there's an article in the Irish Times today, well, the electronic version anyways, of PhD students advising foreign students not to come and do a PhD in this country because the way those PhD students are treated in the universities by cheap labour and getting even less than the minimum wage, if it anything at all.
As one of those cheap labour PhD students, I was going to say, with my PhD supervisor staring me in the eyes. No, look, I think, yeah, look, I also don't represent the university sector, and it's not to be honest, it's not a sector that I would know particularly well. But I think it's I more so see it, and it's from my own exposure on the PhD student side. Look, the reality is that PhD students, look, they vary depending on how much work you do, right? And they'll admit that I'm only part-timer anyway. But there is definitely they're not even they're below minimum wage. It's the reality of the situation. You can have the same argument with apprenticeships, and that's a common one done, particularly with the trades. Yeah, yeah, yeah. Yes. I think, yeah, you're right. but I think the academic sector is seeing something that has been something that's happening across the economy for some time now. I'll compare it to our own experience in the retail sector. The full-time job pretty much is non-existent now in the retail sector. Now, there's very different, entry requirements to those two roles, right? But at the same time, there's a growing informality, and someone touched on like I think Deliveroo or the platform workers as well. There's an obvious and intentional informalization of work. I think it's to some extent been like now that we've reached effectively maximum employment. I think the pressures are kind of swinging, right? The market is swinging slightly in our favor in terms of workers, but that is only temporary. That's the reality of the situation. And one of the things I always say to trade unions in these countries, well, not these, but more so in the trade union sector, conferences and stuff, is that this concept of cathedral thinking, right? If I'm a shareholder in whatever company, right? Let's say Uber. I'm worried about my return in 20 years' time. If I'm a worker in Uber, I'm worried about my salary at the end of the week. And this is the difference. The employers, not all employers, to be fair. We have to be fair. There is good employers out there. But the bad practice employers and the market to some extent, well, not to some extent entirely, is there for the long term. It's looking at these from a macroeconomic perspective, the long-term strategic goals. Workers don't, and it's one of the flaws I think we have to overcome in the sector.
Now, I'm afraid that has us at time. It's 12:05. So with that, I would like you to thank Owen and John in a traditional manner. We have a